This is our third and final part on this webinar about testifying like a canine expert. Our featured speaker today is going to be Gene Ramirez, but let me backtrack just a little bit to let you know how we got where we're at right now. I'm assuming that all of you can see the slide and see the changes. This is the USPCA Best Practices Working Dog Group. This is a product of us meeting here for the last pretty much 5 years, every week, talking about your cases, what the industry is looking at, case laws that have been coming down, deployments of the dogs, training of the dogs, you name it. We've been talking about those every single week, pretty much since COVID began. And we have put out, I don't know, 20, 30 different types of webinars, which Don will talk about at the end. But this is the list right now of our Best Practices Working Dog Group. And if you want to get a hold of us, or if maybe you want to be part of this group, make sure that you let us know before the program is over. My name is David Furlan. My nickname is Lou. I'm going to be guiding you through today's presentation with Gene. But let me go over real quick what Gene covered in the first 2 sessions, which Don has recorded and is up on the YouTube channel. But Don, Gene, and the rest of the gang talked about what an expert witness is, and that is you, how you are that witness, what qualifies you, those type of things. We talked about the canine trainer testimony, and Gene spoke specifically about who is the most knowledgeable in the rule and different types of rules in order to be qualified as a subject matter expert or as an expert testimony person. Talked about the importance of records, staying current in the field. We talked about integrity and ethics and how those things are so hard to retrieve should you ever lose it, and how important it is for you to maintain that quality of life, not just professionally, but personally as you move through your career. We also talked and underscored the importance of polishing your skills and gave you some really nice tips on how to keep those skills up to speed and polished. We talked about depositions, questions that are likely to be asked of you. Steve White had a wonderful questionnaire that was passed out about some of the predicate questions that should be asked of you before you start giving your testimony, to show how you are that witness and how to make sure, or why to make sure, those questions are asked each and every time you testify, and don't let anybody skip over your expertise. We talked about how to dress, and then we come back to Gene showing us how to dress with a wonderful tie and collared shirt. And he, of course, is here with us today. Now, Gene, I could go on for the next half an hour talking about Gene's background, his accolades. Suffice to say, Gene is a wonderful resource, not just for the United States Police Canine Association as the lead counsel, but also in the canine world itself as someone who you can go to for advice on a specific case. He's been used to write briefings, present for Supreme Court, federal district court type of decision making. He's the one that will advise your chiefs, or perhaps your insurance company, or perhaps the municipality itself, on what to best do, not just with your canine case, but pretty much all your use of force cases, especially if they might be SWAT cases as well. He is a well-accoladed lawyer, having achieved all kinds of awards. He has traveled nationwide to teach on police canine legal aspects. Of course, he's available here today for us, and I'm very proud to introduce to you my friend, I want to say my friend, and also my colleague, Gene Ramirez. Gene, I'll flip over to your first slide, but I'll let you introduce yourself, say hi to everybody that's meeting with us today on our third part of testifying like an expert.
Thank you, Lou. I hope I don't disappoint you. Is there anybody here who is not a law enforcement officer? I'd like to know that first. I want to know who I'm speaking to today. I don't see anything popping up on my screen saying that you are anything but law enforcement, so that's good. I've been very fortunate in my career that when I left the LA County DA's office and went into private practice on the civil side representing law enforcement, the very first case that I had was a canine case. And that is what got me in the world of canine. I was with LA County Sheriff's Department, their Special Enforcement Bureau, Canine Services Detail. And that's what got me completely involved in canine. And then I came across the USPCA, Don Slavic, 100 years ago, and he got me involved. And then I started going over to the SWAT side, handling all the SWAT cases at LA County and other agencies. And I've been doing this for the last 40 something years. So hopefully I have something to share. So we're going to talk about direct and cross. I'm going to give you some actual examples out of cases that I have worked on. And to best define what's the difference between direct and cross, I will say, considering it's baseball season, direct is like hitting softballs. You can hit them all day long. Cross-examination is probably best described as trying to hit curveballs. You're going to hit a couple, but you're going to miss a lot. And just understand, in depositions, in trial, you're not going to hit a home run each and every time. The other side is going to score a couple points. Just understand that, accept it, make sure it's on minor things, and then we just move on. It's like, fine, you got me. I'll get you on the next question and answer. So let me give you some ideas what's going on. One of the things that we've been dealing with the last several years that the plaintiff's bar loves to push in either law enforcement cases, trucking cases, pharmaceutical cases, you name it. And it's called the reptile style of deposition or reptile style of trial work. And this reptilian litigation style is that the plaintiffs have learned that they need to appeal to the jurors' reptilian side of the brain. In other words, they want to scare the jurors that if they don't come back against the defense, and we are usually on the defense in the civil case, that the world will lose its societal order and hell's going to descend upon society. So they try to scare the jurors, and they will try to get you, the deponent or the witness, to agree with a variety of safety rules. Generally speaking, you have probably been trained over the years that you are not to volunteer anything unnecessarily. Only answer yes, no, I don't recall, I can't remember, and maybe a small answer. We have to change that philosophy, and I have over the last several years, because I have learned watching some very good attorneys coming against my clients, how they handle their cases, how they appeal to the jurors, and we have to constantly counter that. They're coming up with new theories all the time. So the plaintiffs are going to try to corner you into a box from which you cannot escape unless you lie, you backtrack, or you omit fault. So we don't want to get caught in that trap. So the idea is they want you to agree with them that general safety and danger avoidance should be part of the job. Then they're going to try to get you to agree with more specific safety and danger avoidance rules. And finally, you are going to be forced to admit to violating the rules that you just agreed with. So let me give you some examples of how it popped up in one of my depositions. And it took me a while to realize, because this happened many years ago, this is reptilian litigation. They are trying it out on police cases. It started out with the trucking cases, and then it started with the pharmaceutical cases, and now it's over in the police litigation world. And so we see these nuclear verdicts, which is defined as anything more than 10 million. It started with the trucking cases. It started with the pharmaceutical cases. And now we're seeing in law enforcement that we're getting verdicts over $10 million. We're getting settlements over $10 million. So the philosophies that worked in these other industries are now being applied to us in law enforcement, and we need to be prepared for it. We need to know how to adapt to it. We need to know how to counter it. So let me give you some examples. These are some actual depositions. Question by a very well-known plaintiff's attorney, but I'm not going to tell you who it is. You are trained that you can only use force that is subjectively reasonable, aren't you? Answer, yes. Question, if you use force that is unreasonable, it is unlawful. True. And you cannot use unlawful force. True. Answer, true. Question, if you use unlawful force, you're responsible for the consequences of that use of unlawful force, aren't you? Yes, sir. Question, unlawful force is needless. Would you agree? Answer, yes, sir. So when you get a word like needless or needlessly endangering someone, that's to tip you off. Okay, I got a lawyer who's been trained in reptilian litigation strategies, and that's what they're trying to do to me. Unlawful force is needless. Would you agree? Yes, sir. Question, so if you needlessly endanger someone, that would be against your core values. True? Yes. Question: if you needlessly endanger someone, that would be against your training. True? Yes. And if you needlessly endanger someone based on your understanding, that would be unlawful. True? Answer: yes. So we assume that deputy number one was striking the plaintiff unlawfully, and we assume that deputy number two was striking the plaintiff unlawfully. Any force that you then added as deputy three would also be unlawful. Would you agree? And now the way you respond to that is, I don't think my other deputies were using unlawful force, and I also believe the force I used was lawful. So you have to you're going to have to step out of the comfort zone of yes, no, I don't recall, I don't remember, and start actually defending yourself, even in depositions, and start going outside what you may have learned in the past. Question: would you agree that you've been trained that a sheriff's deputy should never needlessly endanger a member of the public? Answer: yes. Question: you've been trained that way, right? Answer: yes. And you've been trained that if a deputy needlessly endangers a member of the public and that person is injured, the deputy is responsible for that injury. Would you agree with that? Yes. Question: you've been trained that way, right? Yes. You've been trained never to needlessly endanger the public, haven't you? Yes. Question: you've been trained that if you needlessly endanger the public, there are consequences. Isn't that true? Yes. And you've been trained that if a deputy needlessly endangers a member of the public, that deputy would be responsible no matter how severe the injury. True? True. That's how they set you up. So how do we counter that? You will never needlessly endanger the public. Generally, that's true. However, depending upon the facts and circumstances, we may have to do something that may, unfortunately, put the public at risk for the greater good. So don't get caught saying, yep, you're right, you're right. Fight back a little and be able to explain that there are exceptions. There is no straightforward rule. Now, let me follow up with another example. Let's talk about the Fourth Amendment, because you should all know this inside and out. We've talked earlier sessions. You need to know your craft. That means, what is the Fourth Amendment? You all train under. Everything you do as a law enforcement arises under the Fourth Amendment. Pedestrian stops, vehicle stops, obtaining warrants, service of warrants in the courts, use of force, whether it's K-9, a control hold, a baton strike, whatever it is, all that falls under the Fourth Amendment, which means you got to know what it is, right? Because if you don't, we've got problems. Now, this was a line of questions that was asked in one of my shooting cases, but it applies to canine cases as well. Question: do you agree that you have learned about the Fourth Amendment since you started the police academy up until today? Do you agree that the Fourth Amendment is one of the most important rights that we all enjoy? Do you further agree that if you violate the Fourth Amendment, you can be held responsible for that violation? Do you agree that if you violate someone's Fourth Amendment rights, you can be disciplined by being suspended for a period of time, for example? Correct. You can even be terminated from your job, depending on how serious a violation of the Fourth Amendment is. Correct. You can also be sued for violating someone's Fourth Amendment rights. Correct. Now, would you agree with me, officer or deputy, that you would never knowingly violate someone's Fourth Amendment rights? Would you? What does the Fourth Amendment say, officer or deputy? And you better be able to say, everybody has the right to be free from a reasonable search and seizure. That's all you need to know. If you don't know that, settle the case, because the jurors are not going to like you. The reason we win our cases is very simple. There's no major scientific studies that are needed for this. If the jurors find that you were believable, credible, and you know your craft, we're probably going to win. On the converse, if jurors think you don't know your craft, they think maybe you're a good cop, but you had a really bad day, or if you're a liar, you have no credibility, we are going to lose. It's as simple as that. So everything you do, the way you come across in your deposition, because a lot of depositions are videotaped, particularly if they're being done remotely, they're going to be preserved forever. So how do you come across? Do you have your sunglasses on top of your head? Not my deputy, you're not. Your water bottle should not be inside the frame of the camera. It's going to be off to the side, but it's going to be a water bottle. It's not going to be some beer stein that you happen to put water in, because that doesn't look professional. How are you dressed? Are you dressed appropriately? Do not wear your uniform. I do not allow anybody to wear the uniform in my depositions, and certainly not in trial, because that's what got you in trouble to begin with. If you're on steroids, lay off, come back down on normal size. Sorry. Jurors aren't impressed with how big you are. If you are bald-headed, I'm going to have you grow your hair out because you have to come across and look like everybody does. One of the other things about examination, whether cross or direct, is how you answer the question, but it's also the honesty. Honesty, how you come across. It's not bad to admit I was scared. I didn't think I was going to make it home that night. This is why I used that level of force that I ended up using, because I was in fear of an imminent threat of serious bodily injury to me, my partners, or to members of the public. And that is why I responded in the way that I did. They're going to ask you, do you have a reverence for human life? Yes, I have been trained from day one of the academy up until today that we are to have a respect for human dignity. We are to have a reverence for human life. Well, what does that mean? Give me some examples. It means that after I use force, I'm going to get immediate medical attention there. If I shoot someone, I may only limit my shots to a few, reassess and decide, do I need to really fire more as opposed to unloading my magazine? I'm going to use my personal IFAC medical kit on this person right away because it's going to take a while for paramedics to get there, and I want to do what I can to save this person's life. I'm going to immediately call for medical and have them get over there as quickly as they can. I'm not going to swear at people. When they are down and after I'm injured, I'm not going to make crude remarks. I'm going to tell them, hang on, help is on the way. Hang on, medical help is on the way. That is how we show a reverence for human life. And they may ask you for examples. I was teaching a class yesterday for field training officers, and we were talking about giving warnings. We were talking about use of force, a variety of force. And the question came up is, how do you explain use of force? We shoot to stop the threat. What does that mean? Is that a fancy way of saying we're going to kill you? Of course not. And one of the students said, Gene, how do we explain what it means to stop the threat such that we don't look like we are a bunch of trained murderers? I said, you will give an example. Counsel, we are trained to use the number of rounds it takes to stop that threat. Now, for example, if I shoot once, but I miss, but the suspect has surrendered, that is an example that I used that force that was enough to stop that threat. I may have to fire 10 rounds. I may have to fire 20 rounds based on the nature and extent of the threat. So those are how these things are going to come up. Let me give you another example. We can prepare you for the basic types of questions that they're going to ask, but sometimes the plaintiff's attorneys, they will come out of left field and they're going to throw you a curveball that nobody expected. They may hit you right between the eyes with their first question right off the bat, and you have to be able to respond without looking, oh, what the heck just happened? Here's a set of questions that were asked of one of my officers in a shooting case. Do you agree that you're a trained killer? No, I'm not. Well, you're trained to use deadly force, are you not? Yes, I am. So you're trained to kill another human being, are you not? No. Don't you use deadly force when you think the need for deadly force is appropriate? When under the totality of the circumstances and it's objectively reasonable that deadly force is necessary, then yes. And deadly force results in someone dying, doesn't it? It depends. And they will keep going on that line of questioning, and your response is no. I have been trained in a variety of weapon systems, yes. But I've also been trained when to stop shooting. I've been trained to have a reverence for human life. I've been trained that I only shoot when it's objectively reasonable to protect myself and others from the immediate threat of serious bodily injury and or death. And then I say, what does it mean to be objectively reasonable? This is another one of those definitions you just have to know. You can't make it up. You can't summarize it. And what it is, what would another law enforcement officer do if placed in the same or similar set of circumstances as me with the same amount of training? Again, you just need to know the definition of that. They will always ask you, are you trained in de-escalation? Yes, I am. What is de-escalation? You will give a variety of examples to show de-escalation. but nobody really has a definition. In California, our peace officer standards and training, our post, has come out with a manual of de-escalation, which I recommend to all my clients in the state of California. I use it on a daily basis. And it has a standard definition. So when I train law enforcement, particularly in California, I say, guys, we have a standard definition. You just have to know this stuff. Those strategies and techniques intended to decrease the intensity of the situation. It's already there for you. You don't have to make it up on the fly. You want a tattoo? Get that definition. Get the definition of the Fourth Amendment, put it on your other arm. Those are tattoos I will approve of. And I generally don't approve of tattoos, but those I will. Cross-exam. Like anything else in life, it's based on the number of repetitions, the number of times you have been in depositions or in court and actual trial. It's just learning by experience to see. After a while, you'll be able to see where the opposing counsel is going, where they're going to lead you, because you'll see a series of built-up questions, and then they start coming into where they think they're going to attack you, but you're prepared for that. So generally, they're going to start with your background and training, which means you have to have that memorized. I started as a law enforcement officer when I joined the academy in 1970. After a 16-week training academy, I then was assigned to either the streets under a field training program with experienced training officers, or if you're a deputy, I went to a custodial facility for X amount of time where I worked in the following categories. And then after patrol, you'll talk about all your collateral assignments. Maybe you're an FTO, maybe you're a member of the color guard. But at some point, you decide you want to become a canine handler. Remember what the process was that you're going to ask you. What was it, the process for you to become a canine handler? There was a notice saying we're accepting applications for canine handlers. I prepared an interest memo. I submitted it up my chain of command. I then had an oral interview, and then I did XYZ, whatever it might be. I also spent 4 years volunteering as a decoy for my canine unit or other canine units. And this is the additional experience I have gained to show your knowledge and your dedication to the craft of being a canine handler. And again, you just have to know this. How many hours have you spent training? Do you keep a daily book of your training that you do on a daily basis, individually, as a unit, as a shift, as an organization? If you train with other units, just know how often you train. What is it you train on? Because they're going to ask you that. So your training records become hugely important in these cases, because they're going to ask you questions based on your training records. So know them, have copies, make sure your department has not only the post-required training, but that they also have all the additional training you have taken. I attended a webinar on May 22nd, 2025 on how to testify. I attended a decoy or agitator course on such and such a date. I attended training for the USPCA in Tampa, Florida on such and such a date. And these are the classes I attended. Keep that track, keep your own copy in case your department loses it for whatever reason, which we know, because your training coordinator may be overwhelmed depending upon the size of your agency. So you are responsible for maintaining that on your own. Let me give you an example here of some examinations. So this is what I'm going to go over some questions and answers for one of my cases where my canine handler was being questioned by opposing counsel. The use of the dog was caught on body-worn camera. And so I'm just going to spend a little time showing how opposing counsel asked my handler questions regarding his use of force. I'm going to pause it right there at about 3 minutes and 39 seconds, referring to the body-worn camera that Dave just showed. Deputy, did you hear yourself exclaim or give an order to, quote, put your hands behind your back or you're going to get bit by the dog, end of quote? Answer, yes, I said that. Question, is that a part of the regular practice at your agency that you let people know that if they do not put their hands behind their back, that they will have the dog bite them? Answer, no, that's not the practice. Question, is that a part of the policy of your department to do that? Answer, no. We give them warnings when the subjects are fighting with our officers. Put the hands behind their backs. Stop fighting and surrender. We can use a lot of different language to basically mean comply with the deputies, or like I said, a police service dog would bite them. Question, let me ask you, is your dog a dual purpose dog? Answer, he was a dual purpose. Question, what does it mean to be dual purpose? Answer, they're a locating tool and then a narcotics dog. And what does that mean to have a locating tool? Answer, well, they are primarily locating and then apprehension, and they are also narcotics trained. Question, now after you've given this order, put your hands behind your back, or you are going to get bit. Did you see the plaintiff standing when he gave that order? Answer, I did see him try and stand up from the ground at one point during the fight. But at the time he was fighting on the ground with my fellow officers who had assisted and gone in to assist another officer. All right. We were just talking about the moment where you have given the order for the plaintiff to put his hands behind his back or he will be bit. Is that right? Answer, yes. Question, you said that's not part of the practice of your agency, correct? Answer, we're supposed to give announcements, whether they be put your hands behind your back, surrender, give up, stop fighting. We have to give some type of verbal warning if we're going to use the dog as an apprehension tool. Question, at this time, was the plaintiff being handled by more than one officer? Answer, at that time when I made the announcement, I think deputies may have been in the fight, nobody else. If she had been, it would have only been her and officers. All right. Did you observe that time the plaintiff attempting to strike any of the officers with his fist? Answer, I saw his hands going up towards an officer, and then they were moving all around, and then his hands went towards his waistband once or twice during the fight. I never actually saw if he struck any officer, but his hands were getting up near there. Question, I take it then you did not observe the plaintiff attempt to strike Officer A. Answer, I did not observe Officer A. Question, or the plaintiff attempted to strike Officer A, right? Answer, from my angle, I could not tell. That gives you an example, I believe, of how into the weeds they're going to get. They're going to go every little spot. Why did you do that? What could you see? What could you not see? What were the other officers or deputy at the time? What was the threat level? What does your policy allow? Which means you've got to know your policy inside and out. Are you allowing for directed bites? Why or why not? How long will your dog be on the bite? How quickly can you get your dog off the bite? Does your dog verbally call off, or do you have to do something else? Do you have to touch your dog, then give the verbal command? Generally, how long does your dog take before it releases the bite? Have you ever had to use any mechanical means to get your dog to release the bite? Have you ever had to use your e-collar? Have you had to use a bite bore or something similar? Have you ever had a case where your dog refused to listen to your commands and did not come off the bite for a period of time? They will ask about that. If it's discovery, we probably have to answer it. But if it's in a trial, we will have filed what's referred to as a motion in limine beforehand to limit if they're going to get into prior uses of force. We will try to restrict it or ask the judge not to allow that, because then we're going to have multiple mini trials on cases that are not an issue involving people who are not part of this particular lawsuit. And judges are usually hesitant to get into prior incidents, and certainly any incident after the one that's caused you to be sued are generally irrelevant for purposes of that trial. So we're not going to talk about it, but it's up to the judge to decide of any previous incident, particularly if there's been a problem of your dog not releasing and it's been documented. That may come in depending upon the judge. Cross-examination can get a little, crazy. In a depot, tempers sometimes flare. And again, if it's being video recorded, you got to maintain your cool. I will see it and I'll start saying, okay, we need a break. Everybody needs to calm down. Let's take a break, come back. I'll talk to my clients. Say, okay, just relax. They're just trying to get under your collar. Don't let them win. Just maintain your professionalism. This will not last forever, although it may seem like it. So just hang in there. So I try to take a break every hour to give you, the witness, a chance to get your thoughts together, because it's intense. For that 1 hour, you're just answering question after question, and it gets tiring. So I got to give you a break to let your mind relax. Okay, let's discuss their strategy. Where are they heading? Can you see where they're going? Yes. Okay. They may ask you the same question 5 times. They're going to get the same answer 5 times. You're not going to change your answer. If that answer is correct, if they're asking about the policy, I'm allowed to use that force. which is reasonable to effect an arrest, prevent escape, overcome resistance, and I can protect my life and the life of others. That just doesn't change. No matter how they ask it, your use of force policy does not change. When you're allowed to use the dog does not change because that is policy. You have been trained. Now, if there's a discrepancy between your policy and your training, that's an issue. And hopefully you will have discussed that with your attorney before you even get to the deposition. And certainly well before trial, we have already would have discussed that and see how we can make the two coexist. But cross-examination, you're a goalie in a hockey net, in front of a hockey net. You're going to have pucks being blasted at you. You're going to stop some, but some are going to get by you. Like I said, it goes by you as long as it's not major. One of the things that just happened to a friend of mine who was testified as an expert in the K-9 case just a few days ago, they got into his background, and you need to be aware of this. Some of the K-9 experts against you are former law enforcement. They may have friends in your agency, and they may ask, "Hey, Joe, tell me about this guy who's your expert. He used to work there. What person is he or she? What do you know about him? They ever get in trouble? Maybe ever complain about him?" And they're going to try to find out if any lawsuits been filed, any complaints been filed. This is an old trick. I haven't seen it done in a while, but they used to be done when I first started doing this, is the opposing counsel would start searching the divorce records involving my handlers and or my experts, seeing if they could find something in the files, because a lot of times divorces become quite emotional. People say things, and they sometimes say things under the penalty of perjury when they file declarations seeking spousal support, child custody issues, and some pretty horrendous things may be said about you by your spouse. But I've always cautioned my clients is, if you're going through a divorce, talk to your spouse, say, "Listen, I'm being sued. There's potential we could always lose, which would come out of our pocket, particularly maybe if it's punitive damages. So I think it'd be the best interest for all of us if you not put anything of a negative nature in any declarations you file with the court, and I agree to do the same. And let's just keep this as professional as we can so that we're not spending more money on the lawyers. And certainly there's nothing in there that someone could use against either one of us sometime in the future." And you'd be surprised if you've ever gone through a divorce, maybe you're not surprised at what people say about each other in signed legal documents that can be used against you later on. And law enforcement are particularly susceptible to that because these plaintiffs' attorneys will hire private investigators to go find the stuff to use against you. So just be aware of that. It may very well come up. That may be part of the cross-examination. Isn't it true you were disciplined at your former agency for the use of excessive force? Isn't it true you were found liable by a jury previously for using excessive force? And if that is true, hopefully your attorney has attempted to not allow it to come into court, but a judge may allow it because it goes to your credibility, particularly if you're an expert witness. They may allow it in. Then you'd have to be explained what the facts and circumstances were. Maybe it wasn't even dealing with the dog. You were part of several people. They are the ones that used the force, but you were sued as well, and you were found liable even though you didn't use anything. That happens occasionally. So you're going to have to be able to talk about that and explain why you were found liable in a previous case. Now, if you have a history of complaints, sustained complaints, and lawsuits, you probably shouldn't be an expert because you have to realize they're going to come after you hard. And I always check with my experts to find out what their backgrounds are. I usually know them beforehand, but I always double check. Is there anything in your background I need to be aware of? Have you gone through a particularly difficult divorce where your spouse may have said something that we're going to find out about? Why did you retire? Why did you leave your agency? Is there anything, if anybody does any kind of a deep dive into your background, are they going to find something that's going to embarrass us? Now, you, as my client, we're going to have a long talk about your social media use and what you're posting out there, because I found out the hard way defending a deputy on a wrongful death case that he had been posting stuff on the websites when he told me he hadn't. And the other side, the family of the person that had been shot and killed by my client, had law enforcement relatives. They used their sources to go into law enforcement websites and found that my client had been posting horrific things of racial nature, criticizing his supervisors, boasting about the use of force, that I didn't have access to that website. My client denied doing anything until during the deposition, the other side started asking my client questions like, "Sir, did you and your wife ever run a internet travel agency that catered only to law enforcement?" And all of a sudden my mind is going, what is this line of questioning? Because I'm not aware of it. And if you don't tell me something and it pops up, I'm not a happy camper. Yes, I think we did, only for a short period of time, and the company didn't do well. Oh, did you ever use this particular email address and post it on such and such law enforcement website? I don't recall. Did you ever post that you were fired from one agency and went to another and were accused of using excessive force, blah, blah, blah? And at this point I said, you know what, guys, I think it's after 5. Let's go ahead and take a break and we can resume this depot on another day. And they started laughing because they knew they had us. So we get in my car and we're driving back to my office and I'm fuming. My deputy knows it. Goes, "Gene, how angry are you right now?" I said, "I'm not happy because I asked you these questions and you never told me the truth. You said, 'Oh, that's not me, sir. That's not me.' So what I want you to do when we get back to my office is you're going to sit down with one of my attorneys and you're going to show her everywhere you've been and posting on the websites. Do we understand each other?" He goes, "Yes." We drive another couple miles and then he says, "Am I going to lose my job because of what happened?" I said, "Deputy, I don't really know, but I have to call your agency and tell them what happened. You understand that, don't you?" He goes, "Yes, sir, I do." So we go back and I send with one of my attorneys and they're on the computer. They come back in a half hour later. My attorney says, "Gene, you need to know this. After the shooting, comments were being made when there's a news story, people make comments about that news article. And there was a comment made by, I don't know, we'll call him Joe from Texas. 'Oh, you guys weren't there. You don't know what he did,' and blah, blah, blah." And my attorney says, "Gene, that's our client who wrote that." And so we call our client in. I said, "Deputy, did you post this using Mike from Texas?" He goes, "Yes." I said, "Why?" He goes, "They were pissing me off. Look what they were saying about me." The deputy, "You're not supposed to respond to this stuff." I said, "Go home. I got to think about this. I got to call your agency." He goes, "Yeah, I know." So I called the agency and I told them what happened, and he's no longer a deputy. Let's put it that way. And we ended up having to settle that case. So you've got to be super careful what you're posting out there because it can come back and haunt you. So I have more than gone past my time, and I apologize, Lou, and everyone else, but I wanted to much things, topics, and examples as I could out there. And I hope everybody finds that this is helpful because I want you all to succeed. I really do.
Before you leave, can you talk about Barnes versus Felix for 1 second? Can I grab you for just a little bit longer to talk about that case?
Yes. On May 15th, the United States Supreme Court came out with an opinion that a lot of people have been talking about because it involved the use of deadly force. And we're trying to figure, okay, what is the standard they're going to use? It arose from a officer-involved shooting in Texas. It was a traffic stop for a bunch of unpaid tolls that were picked up by some traffic cameras. And the local officer there saw this come across his computer screen, pulls this guy over. He starts talking to the guy, tells him to turn off his car, turns it off, and then turns it on. The officer then jumped onto the car and it takes off, and he starts firing a couple rounds into the cockpit, ended up shooting and killing the driver. The entire incident was like 2 seconds passed between the moment the officer stepped on the door sill and the moment he fired his first shot. Now, in the Fifth Circuit, they had a standard called moment of threat rule, which means you only analyze the use of force at the moment the threat arose. In this case, 2 seconds, at most 5 seconds. So the trial court said, it was a federal lawsuit, said, based on our moment of threat rule, the events leading up to the shooting are not relevant. So the precise moment of threat was the 2 seconds when the suspect took off in his car with the officer on the car. That's all we can look at. And based on that, the officer could reasonably believe that his life was in danger. So the district court, the trial judge, granted the motion for summary judgment, which is the motion to dismiss the case. The plaintiff then appealed to the Fifth Circuit Court of Appeal. And the Fifth Circuit Court of Appeal says the district court followed our rule of the moment of threat. So we have to affirm that granting of the summary judgment. Then the plaintiff appealed to the United States Supreme Court. And the U.S. Supreme Court said, our analysis of a use of force under the Fourth Amendment requires a reasonableness test. And that reasonableness test requires us to look at the totality of the circumstances. Because within Graham versus Connor, if you remember, in talking about reasonableness, the court says we're going to look at a use of force from the perspective of the reasonable officer on scene, not with 20/20 vision hindsight, but we have to look at the totality of the circumstances, which means everything at the time that caused that law enforcement officer to use whatever level of force they chose. Prior events may show why the use of force is reasonable. Prior events may also show why the use of deadly force in this case is unreasonable. So the Supreme Court says, even though the parties are talking about, did the officer create this exigent circumstance himself? Did he put himself in harm's way such that he had to extricate himself by using deadly force? Supreme Court said that's not the issue. We're not going to address that issue. The only issue we're going to address is whether the moment of threat rule applies. And we said, we're going to send it back down to the Fifth Circuit and say, no, you have to look at the entire totality. And they cited a case, a great case for us. It came out in 2014 called Plumhoff versus Rickard. That was a 5-minute chase. The suspects crashed their vehicle at the end, but the suspect has his foot on the gas pedal, so the tires are spinning, and officers fired multiple rounds into that car, killing the suspect. So the Plumhoff rule was you are allowed to fire the number of rounds it takes to stop the threat. That's the first Supreme Court case that actually came out of it. But what the court also said, Plumhoff says, the plaintiffs in that case, the ones who appealed, said, wait, you can only look at the use of force at the time that it was used, which is at the termination of the pursuit. And we think it's unreasonable use of deadly force. Supreme Court said, nah, we look at totality of circumstances. We have to look, what did the suspect do previously? This was a 5-minute, 100-mile-an-hour pursuit. He crashes. He continues to keep his foot on the gas pedal, causing the tires to spin. Then the officers reasonably believe they're going to take off and cause more damage. No, we're not going to look at it from just the moment that they crashed and they fired the weapons. We're going to look what happened preceding. Most states already followed that totality of the circumstances analysis. I know in Ninth Circuit, I've been dealing with that from day one. But now the Fifth Circuit and those other circuits that follow the moment of threat rule have to start re-examining use of force under the totality of the circumstances. In a nutshell, that's what Felix versus Barnes came out with. Hopefully that gives a pretty good summary in a few minutes.
This is outstanding. This is terrific training, right? It's cost-effective training. Gene, it's wonderful to hear from people like you who are in the front lines, who are in the field, giving us real examples of what is going on out there so that we all can learn from this. And I'm really appreciative of it. But let me move on to some of the questions that either you can answer or those that are in the panel can answer. Let's open this up a little bit and let's see if we can handle some of these questions that have come in, not just from today, but also from previous seminars, Gene. Well, the first one I would like us to tackle, either you or anybody else, one of the most common challenges that you see defense attorneys raising against the canine handlers in court. What are the most common challenges that you are seeing?
I will defer narcotics questions to Scott and Steve and some of the others, because my cases are all apprehension dogs. Rarely are canine handlers who are doing narcotic searches going to get sued civilly. And I haven't done criminal cases since 1990. But on the civil side, they're going to ask you about your training philosophy, which you all know is different than your deployment policy. So they may get into it, guard and bark versus find and bite. And I hate those terms. I don't care if your dog is sit and piss. It makes no difference to me, because that's just a training philosophy, which means nothing to me. It's either a justifiable bite under Graham versus Connor or it's not. I will also tell you, I have tried, I don't know, 12, 15 canine cases, state and federal court. Never once have I had to argue in front of the jury whether we were guard and bark or find and bite. We just argue whether it was an appropriate use of force on the Graham versus Connor. So I don't get wrapped up into what people talk about as to their philosophy, because I also know a lot of guard and bark dogs that they are deployed as find and bite dogs, but they think that guard and bark title protects them some way. Doesn't. It's no different. I'm actually a big proponent of find and bite because it means the handler is going to work closer to the dog. It's going to be able to call that dog off more quickly, and the burden is placed on the handler, not the dog, which is where it should be. But again, I put that aside. It's either justifiable bite or it's not. That's the way I look at it. Now, for those who have the experience in the narcotics world, I will defer to them on what challenges are going to come up.
Let me add to that then, for those who are going to answer that way. Let's talk a little bit then about the false alerts, improper cueing, maybe a residual odor. Let's talk about some of those things that come up in court for some of our scent detector dogs more than the use of force dogs who wants to raise their hand and go. Go ahead, Steve.
Thank you. When it comes to detector dogs, the attacks come in one of two forms. One of the ones you just described, which amount to training / handling / deployment decision issues. In other words, did this dog actually respond to odor, or did the handler cue that response? Or was it a hybrid? The handler saw a change of behavior and then cued the final response. If so, you just got to be honest about it. It's okay to make a call based on a change of behavior. The trained final response is the ultimate thing we'd like to see, but there are circumstances that can intervene. You can take care of that. But the next avenue attack that is getting popular right now is did the dog have the right to be where its nose was? Because that's what's doing the work. And now particularly with vehicles, there are arguments that once the dog's nose breaks the plane of a window and enters the passenger compartment or some other protected area of the car, that's a violation at that point. That's a Fourth Amendment violation. And at that point, we have to see, because different states are interpreting it differently. The federal courts have not weighed in on how the different states have addressed this. So we're going to have to, follow our own state's guidance and make sure that we follow the U.S. Supreme Court's ultimate guidance. And Harris is probably still going to be your main framework for that. Go ahead,
Don.
Sometimes we talk about this privately as we build up the things, videos such as this, informational videos, is that what should we talk about the camera and what the camera sees? And is there things that we should say? Should we be repeating that my dog just had a behavior change? Seems how you brought that up, Steve. So that because the camera may not see that actual behavior change. Is that something we recommend or we should think about doing?
It's off the topic for the expert witness piece, because this is something that happens beforehand. But the answer, as always, is going to be, it depends. And it depends upon how well and clearly you've established what different forms of behavior change mean to you. And you can make a thing, gait change in faster sniff rate. You can make those comments. They don't necessarily mean you're at source, but you can aggregate them to give you the information. So those are data points that you can articulate as you go. But just remember, anytime you put something on a recorded medium, such as your body cam, it's there for everybody to see afterwards. And there's no perfect answer on it. Everything's about trade-offs. What are you willing to give up to get what you want? And in this particular case, you're trading off clarity of a final response or a final call by the handler with all the stuff that leads up to it. That means when you're called to testify about that or write about it, there's a lot of filtering that your listeners or readers are going to have to do. So you make the call for yourself about whether it does and doesn't help. The one thing that for example, let's take it from the detection world to the patrol world. Now we're back in Gene's realm, and with tracking dogs, you can make articulation about changes of behavior as the track proceeds. But I would caution you that if you have somebody handling radio for you and doing the radio thing that's part of your search team, don't let them make statements about the dog is in or out of scent. In other words, coach your people before your search, probably before the day of the search. This should be something standard knowledge that with the people with whom you work, that leave the specifics and the interpretations to you. They just say things like, we're turning south now. We're turning north now. Dog is working an intersection. You can say things like that are objective, observable things that anybody could see. Leave the interpretation to the handler.
Let's extend that, Steve. And even in an actual apprehension deployment, before that should be a training day, you will not make any inappropriate comments that would be picked up by anybody's body-worn camera. So if the dog goes in for a bite, I don't want the backup officers or deputies say, oh my God, that dog's really chewing him up, teaching him a lesson. Because that has happened in the past.
Big time.
If the handler is responsible for the professionalism of the deployment of the dog, there is not going to be any profanity used. There's not going to be any militarization terms used. My dog had missile lock on that suspect. It's going to be as clean and as professional as possible. Because you got to remember, the ultimate reviewer of that video is not going to be your sergeant, lieutenant, or chief, or sheriff. It's going to be a jury or a judge. And how are you going to come across on that video? Just my 2 cents worth.
And that's more than 2 cents worth. We're coming up to our point, but I want to go over one question while I have you here, Gene. I want to go over question number 7, which is, how should I handle discrepancies between my report and my testimony, which I'm sure you have seen with your experience as a trial attorney. And anybody else who wants to opine on this, please raise your hand and let's hear from you. How are we handling the discrepancy between a report and now the testimony or a deposition?
It is incumbent upon the handler when they write the report. If you have video, you better watch that video before you prepare that report, or simultaneously watch your video and write your report, because you are off. Let's say your report says my dog was on the bite for somewhere from 5 to 7 seconds, but then we watch the video, we may count it up to 15 seconds. Handler, are you trying to downplay the length of time that your dog was on the bite intentionally? Why didn't we're looking at your video and we're watching the counter there? How are you off by so much? Or you describe the injuries as minor, but yet the doctor said these are major. So I'm trying to tell my handlers, you're not a doctor. Be careful how you describe injuries. Always try to refer to the medical reports. But there will be minor discrepancies. I can deal with the minor discrepancies. It's the big ones. The length of time on bite. How many warnings did you give? What was said to the suspect? What did you do to de-escalate before we use the dog? That stuff has to be spot on. Spelling, huge issue. If I ever decide to go to the other side and start suing you, law enforcement, I'm going to look at your report first and foremost, because that's where I'll find the best meat to attack your credibility. And a lot of times you use the wrong penal codes. You have typos. It's not a big deal in the real world, but when I'm coming after you, attacking your credibility, that becomes a big deal in a court, and it gives me something to show off in front of the jury that you don't know your job.
True lessons from the field here. Anybody else want to add to that?
And by the way, I'm not going to the other sides. I'm just using that as an example.
Thank God. Please don't. All right. Listen, we're at our hour mark, and we're going to be wrapping this up. Again, the first 2 parts are on tape on the YouTube channel. You can watch that. This will be also on YouTube. One of the beautiful things about these webinars is it comes to you, to your training group, or to your office, and they're on demand when you want to watch them. Make sure you record these, or at least document these into your training logs to show that you have received this type of in-service training. You don't have to spend all kinds of money to go to different conferences or events to see some of these experts. You can come right here and see them for an hour webinar type of thing and get their true experience from the field and how things are working, and to hear directly from these frontline experts. I just think they are a wonderful opportunity for all of us to learn more, to get on the same page, so that we are not making mistakes that someone else might have made, but yet we are moving our industry forward. We are moving the beautiful world of police canine as a public safety tool forward for the next generation to enjoy. So I appreciate you being here. Don, I will turn it over to you to wrap this up. And I am very much honored to be part of this USPCA best practices working group. I very much love meeting with you guys every week now for at least an hour and a half to talk about the different things that are in the United States going on with the police canine world. And I was very much honored that you asked me to lead this group for this webinar itself. And now I'll turn it over to you, sir. Thank you.
Yes, we've had a couple of questions. I forget the first person's question, but do we have any webinars coming up that would just be for narcotics only type canine deployments? That's a great question. I don't know. In general, we sit down and pick things, but that's one of them that we're going to be looking at. Go ahead, Steve. Do you have one?
No, that's it. I was just answering in the chat. I was answering that question there.
Okay.
Basically,
then
I think it is a topic worth addressing, and we'll probably bring
Yeah.
in somebody with specific expertise in that realm to support the presentation.
And just building on the question itself, if you have some things you'd like to see us do, because what we do is we look at court cases all day long, every day, all week, deployments. We do some training videos. This will be the 78th video that we've had on YouTube. And we look forward to hearing from you. If you have some thoughts about what we should do next or what we could do next, you all had to ask me for a link. So you have my email. Just shoot me an email, let me know. And like I said, this is like number 78 on our list of videos that are on our webpage. And we are looking at a lot of things that what we do in a sense, in essence, is that most people they understand what's happening in their area. They're good about everything that's in their area, but they don't see the things that are coming outside of their area, outside of their state, outside of their circuit court. And we are finding out that circuit courts that don't have case law based upon something someone has done will look at another case law from another circuit to get an idea on how to write theirs. So we look at a lot of that. And then from those, we get the idea of how to do courses and things such as this. We also have some really talented dog trainers in this group. Lou is a retired chief of police, by the way. Scott Sargent was the use of force commander in LAPD, and now he worked with the DOJ on consent decree. So we have a lot of experience here on different things, and we're trying to put that out as we think that you would want to have. So please look at some of the videos. If you didn't know we had all these videos, they're on our website. They're on our YouTube channel, and just at uspca.com. And that will get you usually to everything else. Barring anything else, I'm really happy with this video again, and what our group did a nice job, and I look forward to doing another one for you. Send me an email. Let me know what you'd like to have done next. Thank you. I really appreciate it. Have a good day.